submission you've just heard plainly hasn't read carefully our letter, and I appreciate Mr. Nice had not seen it before today, although it was copied to them on the day that it was issued. The reason for writing this letter to the Registrar on the 26th of October, after the Appeals Chamber hearing, was that the issue of the assignment of counsel was an entirely distinct issue from that which we were forced to deal with personally as assigned counsel. These two matters are not in any way connected. The appeal on behalf of the accused that we took dealt with the assignment issue and the modalities. And in fact, I point out to the court, prosecution actually objected to us appealing the modalities, saying that it was an entirely separate matter, although plainly the Appeals Chamber didn't find any jot of sense in that application. When we got to the Appeals Chamber hearing, we knew that by the time we'd got to witness number 5, that our position had become increasingly untenable. And during the hearing, when I was in a position to have to explain the breakdown in relations between assigned counsel and the accused and what had happened, and referred that to the Appeals Chamber, it was decided the moment that we walked out of this court that we had to logically express that in a proper way to the Registrar, who has a power under Article 19 of the Directive on Assignment of Defence Counsel to deal with the issue. So this was not any attempt to appeal the issue of assignment at all. It was a professional step taken in consultation with our bar. We'd referred the matter as well to the Association of Defence Counsel, who I may say today have told us that their disciplinary committee, who've had a review of this entire matter, totally support our position and understand it, and I believe are issuing a draft statement later on today. But we felt that professionally we'd reached the stage at the culmination of that Appeals Chamber hearing where we had argued ourselves into an untenable position, and therefore this matter had to go back to the Registrar, whose directive had appointed us in the first place. He referred it quite properly under his own motion to the trial chamber, and yesterday we put in a formal and expanded motion on this issue, which is a development from the 26th of October. It quite plainly is a fair trial issue. I was asked about the jurisprudence earlier on. The lines of decisions dealing with this particular problem are all entirely consistent. It's been pointed out to me that Your Honours, Judges Robinson and Kwan were in the case of Milosevic, where again you ruled that matters relating to the assignment of counsel for an accused affect the conduct of a trial. The Chamber has a statutory obligation to ensure the fair and expeditious conduct of the proceeding.
That was before Blagojevich, though.
But it's precisely where we are.
Are you saying it's consistent with Blagojevich?
It is a matter to do with the fairness of the trial.
Mr. Kay, you've just made reference to the Association of Defence Counsel. At the moment, I haven't the remotest idea what possible relevance something said to you by an association could have in the submissions that you're making before us. Could you help me on that, please?
Certainly. The ADC is a body that was established through the registry of this court, as a way of assisting in the development of defence counsel, their terms and conditions, their education, matters concerning their involvement in cases, and are the official body by which members of the bar join if they're in the conduct of a case here. And they have a disciplinary committee. The executive committee appoint a disciplinary committee on an issue. They were naturally referred to by us as we were taking something that was a matter of professional conduct. And it is of concern to them, the position that we find us in, because we feel in many respects we are standing for a position of integrity to make it clear to the court what can and cannot be done by assigned counsel. So there are two issues. There's the assignment issue, which we dealt with, and then there arose and came about after 2 months our professional position, which we naturally would seek to consult others associated with the issue to take their advice.
It seems to me very odd to make a submission about something an association thinks orally in the context of a hearing such as this, and expect us to give any weight to it when we haven't the remotest idea what were the factors considered by them, and without anything presented in writing. So I, for one, for my part, make it clear to you here and now that that will play no part in my determination of this.
Well, if I'll just explain to Your Honour, they were provided all the materials that Your Honour was provided, and asked to review the issue and the professional course of conduct that we were embarked upon, and whether, in their view, they disapproved or approved. And for us, it is an important issue, as it would be to consult our own bar on the issue. These two matters concerning the assignment are not linked, and that is not our position. As I have said and made clear, it may well be possible for the court to assign counsel, giving them particular roles and responsibilities in relation to the conduct of this trial. We now come before the court with experience, having tried to implement in good faith to enable this defence case to happen. But we ran up against obstacles that have caused us to consider our professional position. And in our view, the registrar rightly referred this matter to the trial chamber, it having come about as an issue relating to the conduct of this trial and its overall fairness.